Hello everyone, I welcome you all at Smarty Education. So today we will be continuing our lecture number 4 of Law of Tort. This is the final lecture of Law of Tort, I hope so. So now let us discuss vicarious liability of the state. So what do you mean by vicarious liability of the states? Let's see. So first of all, let's discuss the position in England. What happened in England? So at common law the crown. So what do you mean by crown? Crown means the king could not be sued in tort either for wrongs actually authorized or committed by servants in the course of their employment. So whatever king said, and if something goes wrong and it will be considered as wrongful act, the king cannot be sued in the court. But until 1947 he was not sued. But as soon as the Crown Proceeding Act 1947 was produced, the crown is liable for the torts committed by its servant, just like private individual, just like a common man. Crown is now vicariously liable for the torts committed by its servant or by himself. So what do you understand by the position in English? So what happened that earlier the crown means the king, whatever he had ordered to servant. So if the servant committed a wrong act, then the king will not be responsible for that. But due to procedure of Crown Proceeding Act 1947, what happened that the king is to be liable just like a private individual to pay the damages. Now let's talk about vicarious liability of the state. So let's discuss the position in India. Actually the Crown Proceeding Act is applied to England, but it cannot be considered in India. We have no statutory provision with respect to liability of state in India. When a case of government liability in torts comes before the court, the question is whether the government activity which gave rise to the tort was a sovereign function or non-sovereign function. So what do you mean by sovereign or non-sovereign? So first of all, get to understand that what is sovereign function. Sovereign function means which is necessary to do. For example, lockdown in India was necessary to do, and right to freedom was not prohibited, but it was since necessary, it will be called as sovereign function. And non-sovereign function means the function which the state did all on its wish, desire, which is to be liable to pay the damages to the victim. Okay. If it is a sovereign function, it could claim immunity from the tortious liability, means the state will not have to pay any kind of damages. Otherwise, the state has to pay the damages to the private individual, which will be termed as non-sovereign functions. Now let's talk about torts or wrongs to personal safety. So personal safety means which is the right of an individual to be safe and to protect himself. The first one is battery. Battery means use of force to threaten someone. Assault means I have not harmed anyone but still giving warning to harm. It will be considered under assault. Third one is bodily harm, means physically harming someone, like murdering someone. Now this is a very important. False imprisonment means on the basis of false proof, the court gave the punishment to the accused that you have committed a tort and you will have to pay the damages, even you will go to the jail. So it will be covered under false imprisonment. Malicious harm means wrong harm. For example, there were two neighbors, A and B. So there was a murder of M, and B had a personal enmity with A. So what happened that when the detective or police came to B said that I have a doubt on A. So it will be considered under malicious harm. Nervous shock means relief from injury, means getting the damages. Defamation means harm to the reputation of a person. For example, you all remember the case of Vivek Oberoi with Salman Khan, in which Vivek Oberoi did that. Vivek Oberoi harmed reputation of the Salman Khan, and Salman Khan can case him under the wrongs to personal safety. Now this is the last topic. I hope now you have patience. Please have the patience. Then we will discuss some questions. Okay, damages. The plaintiff can claim the damages. The first remedy in tort is you can claim damages. Second one is injunction. Injunction means authority warning order. For example, you have seen lecture number 2 in which there was a case of Rakul and Shyam. What happened that Shyam could say that please Judge Saab, please give him a warning so that he doesn't commit any tort again. Means wrongful act, he doesn't enter into my property. It will be covered under injunction. Third one is specific reconstitution of the property. For example, it means if someone is forcefully moved, means if I am moved out of my property, then I can recover that property. This will be considered the third remedy of tort. Now let's time to solve some MCQs. The rule of MCQ is that I will tell you, you have to pause the video, think of the answer, I will tell you the answer. The first is tort is a species of, it cannot be criminal wrong, it cannot be breach of contract, it can only be civil wrong. Let's check the answer. Okay, now let's come to the question second. Please pause the video, think of the answer. I assume that you have paused the video. The law of tort has largely developed through judicial decision that we read in lecture number 1. The third is the law of tort deals with defamation, trespass, negligence, all of the above that we read in lecture number 1 and lecture number 2 and lecture number 3. Okay, ji. This will be considered all of the above. The next question in tort, the remedy is unliquidated damages. When master is held liable for the wrongful act of his servant, the liability is called vicarious liability. In law of tort, meaning of unliquidated damages means penalty. Okay, last question. Injurious in damnum means injury without damage that we read in lecture number 2. So that's it for today's guys. I hope you find the video helpful. If yes, please give it a big like. And if you want to join my WhatsApp group, you can message on this number.